Welcome to The Legal Truth, the podcast created to provide you general legal information about South Carolina law, lawyers, and the legal process. We will answer many of the questions I've been asked during the past 35 years about South Carolina personal injury claims and workers' compensation claims. My name is Derek. I'm the founder of the Derrick Law Firm, and I'm your host.
Please see required ethics disclaimers in show notes.
Welcome to The Legal Truth. I'm here with co-host Pearl Carey. Welcome, Pearl. Today we are talking about the truth about the validity of your personal injury claim. And that's probably one of the most common questions we get when people call in, do I have a claim? And today we're going to try to explain some questions to give people better information as far as what may or may not be a claim.
Absolutely. Thank you so much for that introduction, Dirk. I'm so excited to be back on our podcast today. And so first off, I have to ask, what criteria must be met for someone to have a valid personal injury claim in the first place?
There are three main elements to having a valid claim.
Okay.
There's a bunch of facts, but there's really three main categories. When I was in law school, the professor taught it as a three-legged stool. With any three-legged stools, you need a solid leg on all three places.
Right.
Because if you have a weak leg and you sit on a three-legged stool, you know what's going to happen.
You're going to fall over.
You don't fall over. So the three legs that we investigate in every case is liability, the liability leg, and that is whether or not someone has been injured by an action that falls within a theory that the state recognizes as a cause of action in South Carolina.
Okay.
For a typical car accident case, you have to prove duty, negligence, causation, and damages.
Okay.
So that's the liability leg. You also have to prove that the plaintiff wasn't more than 50% at fault on the liability leg.
Gotcha.
So that's the first leg we're investigating from day one.
Right.
The second leg are the damages. In South Carolina, the damages are medical bills, lost wages, pain and suffering, loss of enjoyment of life, past and future loss of earning capacity, future medicals, impairment restrictions. So we're looking for those damages under the damage leg. Those are actual damages. The second kind of damages in South Carolina are punitive damages, and that's when someone acts recklessly, more than just negligence.
Okay.
And they're reckless, and then you can recover, in some instances, punitive damages, which is an amount of money that will punish the wrongdoer.
Right.
And that amount can fluctuate depending on the degree of recklessness and what the entity is that committed that reckless act, whether it's an individual or a corporation. And the third leg is collectability. Collectability is the ability to be paid for the damages that were caused by someone's negligence or recklessness. My granddaddy used to say, you can't get blood out of a turnip. Legally, what that means is you can have someone who has awful liability. They were reckless. Okay. You can have major damages, but very limited insurance and no assets. So the collectability of that case is very low. That would be a weak leg on collectability.
Can't really get a lot out.
Can't get a lot out. And collectability sets the cap of what you can receive, no matter how strong the other two legs are.
Okay.
So when a case comes in to us, we immediately start investigating liability leg, the damage leg, and the collectability leg.
Okay.
And those three legs kind of play together in determining the strength of a claim.
So what you're kind of saying is if one of those three legs is missing, there's really not a whole lot you can do?
Well, if we investigate and can't find any facts and elements that we can add to that leg to strengthen it, you would have a weaker case if one of those legs are weakened, or if one of those legs are weak. The truth is, very rare does someone walk in and have perfect three legs.
Okay.
We're always working with two strong legs and a weak leg that we got to build up. Or,
Right.
It's not always three strong legs. So you don't have to have three strong legs to bring a claim. But when you start investigating that, you will determine whether we need to spend more time investigation, building the case up, hiring experts if we need to.
Okay.
So it's a model that we work under.
So kind of turning back to the facts of a case, when we're talking about, liability and finding out who's really at fault, how can I determine who's at fault in my accident? What does the process kind of look like for that?
Our process and my belief is we need every fact that
Right.
exists in this world about this incident.
Okay.
And those facts don't only include what happened on that day when the incident occurred, but going backwards
Everything before.
and then going forward.
Okay.
Every case has hundreds of facts, and there's facts that strengthen your case and make it more valuable. There are facts that weaken your case or make it less valuable, and then there's neutral facts. But we want to know all of them.
Yeah.
We have, as of today, taping this podcast, I think we have 7 or 8 private investigators on standby that when we get hired, we contact them that day or within 24 hours with a to-do of investigations
Okay.
that we want done.
Yeah.
Because evidence disappear. We need facts. So, gouge marks or skid marks disappear off the road. Surveillance cameras right over themselves, so you can get surveillance and see what happened.
Yeah.
But then it writes over itself and disappears. Witnesses disappear. People forget things. Almost all cars have data boxes in them.
Okay.
And if we can get those, it will show what the drivers were doing right before the wreck.
Oh.
So we want to download that information before it gets gone, gets demolished in a
Right, and then it's gone.
It's
That's
gone.
it.
So the most important thing about facts is to get them fast and before they disappear.
So kind of speaking of, getting help faster, moving our case along as quickly as possible, so making sure we can gather all that evidence, what kind of time period do I have to kind of get medical attention if I've been in a car accident, or what would you kind of recommend in terms of, getting things done quickly in that sense?
My recommendations as far as the plaintiff or the person who's injured, number one, get medical attention if you need it.
Okay.
We don't tell anybody to go out and get medical attention if they don't need it.
Okay.
If they need medical attention, they need to get it. Now, the truth is, there's people at the scene of the wreck and the adrenaline's pumping, and they wake up the next day and they're hurting, or wake up 2 days from now and they're hurting.
Gotcha.
But they need to do for themselves, from an injury standpoint, what they would do, ignoring the fact there was a wreck that caused it. Second thing on facts I would recommend to people who are injured, stay off social media.
Right. I think we talked about that in our last podcast, like
Yeah.
how important it is to kind of keep things private at
Don't
first.
pull out the phone and start posting at the scene of the wreck or posting
Right.
afterwards. That's the first thing the insurance company's going to look at, or one of the first things. They're going to look at your social media and see what you had to say about the wreck, or what was put on your social media
Right.
after.
How things
So,
might appear online. Okay.
third thing is to do what your doctors tell you to do. You can't come in and claim you're injured and you're not doing what the doctor has recommended. And then the last would be, whether you hire us or whoever you're going to hire, you do need to get someone in your corner investigating the case.
Okay.
Like we just said, evidence disappears. And a lot of times there's delays, and some of them are very understandable delays.
Right.
If somebody's hurt bad, or if someone's been killed in a wrongful death case, if that happens to my family, my first thought's not going to be, hey, I got a lawsuit.
Yeah.
And
Let me call my
let me
lawyer
go get
real
a lawyer.
quick.
And
Yeah.
that's totally understandable. The truth is, it can hurt you in the long run when you don't get the evidence as fast as possible.
Right.
But that's totally understandable.
Yeah.
I mean, we've had cases where people have been injured bad, and they don't contact us for 6 months. And
They've got other stuff to worry about, probably.
that's right. That's
Yeah.
right. And, I always think, man, I wish I had it the week afterwards, so I'd have gotten this piece of evidence and this piece of evidence to
Yeah.
help this family
Ugh.
because it's gone. But it's understandable. I always wish that someone in the family who's just one step out of the
Yeah.
main family would say, hey, I need to take care of this and
Right.
make sure this is getting investigated and documented. And even if they going out and taking photos at the scene
Right.
or doing some investigation, just so that we'll have some stuff to work with when those people end up wanting an attorney to pursue the claim.
Kind of speaking about the car accident example again, what kind of evidence should I be gathering at the scene? Let's say I did just get in a wreck and maybe my adrenaline is pumping and I'm feeling like I can get photos or whatever. Is there anything specific you think I should look for first?
I see some of that. I'm not big on my clients gathering a bunch of evidence at the scene.
Okay. So you think maybe like a private investigator should
Yeah,
be kind of doing that, or a family member?
We're going to do that.
Okay.
Now, if it's a fender bender and you're not hurt, they're not hurt, and you probably may not even need a lawyer, and you may want to document it yourself.
Okay.
And take pictures of the vehicles,
Yeah.
and the contact zone, and if there's skid marks. And then the names of witnesses. If there's one thing that a client could help us with is if anyone talks to them at the scene to get their name and number so we can contact them. I've been practicing a long time.
Yeah.
Well, obviously.
Right.
Yeah. It used to be 20, 25 years ago, if there's a wreck, you had all these witnesses. And we'd get these names and telephone numbers because everybody would stop. They'd wait for an ambulance to get there, wait for the cop to get there.
Right.
They'd leave pieces of paper with their names and number on it. And
Not so much anymore.
2023, we can
Yeah.
have a wreck out on 501 in front of Tanger or on the interstate in North Charleston. And there's all kinds of witnesses and nobody stops.
Wow.
Nobody leaves a number. So if anyone's at the scene and you have independent witnesses, getting their names and numbers, probably the most important thing that a client could do.
So why would you kind of discourage a plaintiff from getting their own evidence? Do you just feel like maybe that would look bad if they're posting stuff about it? Or is there any specific reason for that? Or do you just think it would be better for an actual investigator to look into it?
So it's good to preserve evidence. Skid marks can disappear.
Right.
If you contact someone early on, they can get pictures of the two vehicles and download the data. And I guess it depends on how quickly you get someone to help you.
Okay.
If you think try to handle it yourself, there's no bad injuries.
Yeah.
Maybe document as much as you can.
So you're kind of just saying that it's important to strike an appropriate balance, maybe not over gathering information initially and maybe not doing anything at all. Okay, that makes sense. So kind of going back to the health aspect of things, I know that you mentioned that if a plaintiff, gets out of the car after their car wreck, their adrenaline might be pumping and maybe they don't feel necessarily like they have any pertinent injuries right away. Do you still think that someone like that should go to the doctor just in case on the same day or maybe the day after? Or does that kind of go into the whole realm of over investigating or over treating?
I think people should do for their health what they think they should do for their health.
Okay, so it's kind of subjective.
As if there hasn't been a car wreck.
Gotcha.
I don't think people should go out and run to the doctor because of anything other than their concern about their body or the health of their children in the back seat and that kind of stuff. I've told a lot of clients over the years, just treat this as if this is a condition that has nothing to do with the wreck. What would you do? Listen to your doctor.
Right.
Don't run out to try to build up fake cases. But at the same time, if you are hurting and you're just not toughing it out, that can be used against you too. Understand, insurance companies have a job.
Right.
Their job is to make money for their shareholders.
Absolutely.
By paying as little as possible.
Yeah.
And they take any facts that you give them and they spin it one way or the other. So if someone goes to the hospital after a wreck to get checked out, which is a reasonable thing to do,
Right.
they just ran to the hospital. They told the officer they weren't hurt. If someone doesn't go and they wake up the next morning and they're hurting, or they wait 2 or 3 days because they think it's just sore, they don't get over it. Well, that person wasn't hurt. They didn't go for 3 days.
Right.
So
either way,
they don't spin it either way.
Yeah.
I think people should take care of their health, do what they think they need to do for them and their families. And then from a legal standpoint, as long as they're being honest, which is the most important thing for any plaintiff to do, any injured person, is just be honest. Then they're the easiest to present to a jury.
So what you're saying is that you honestly should just not overthink it and just try and do what's best for your health in the moment.
I think do what's best for your health and be honest with everyone you deal with.
So kind of going back to these insurance companies, can I pursue a personal injury claim if the other person involved in my wreck is underinsured or maybe they don't even have insurance?
Yes.
Okay.
In South Carolina, if you're a South Carolina resident, you have what's called uninsured motorist coverage on your car.
Okay.
It's mandatory insurance. So if you got $25,000 in liability, you'll have $25,000 in uninsured motorist coverage. That pays for damages to you caused by an uninsured driver in another vehicle. Underinsured motorist coverage are damages that you can recover if the person who hits you or causes the wreck doesn't have enough insurance. They have some insurance, but not enough. So both of those policies, underinsured motorists is called UIM, underinsured motorist, is not mandatory.
Oh, okay.
The law in South Carolina is that the insurance company has to make you a meaningful offer of underinsured motorist coverage.
Okay.
And the only way they cannot put it on your policy is if you sign a rejection form saying, I don't want it. Now, from my standpoint, it is very cheap insurance and you absolutely should get it.
Okay.
Underinsured in a state where the minimum level is $25,000 per person on liability, which means the most you got to have on the road is $25,000 per person,
Okay.
$50,000 per accident, and $25,000 for property damage.
Gotcha.
I'm riding in the car with my family. There's 4 of us. You hit us. The most any one person in my car can get $25,000.
Okay.
And the cumulative cannot be any more than $50,000. So you're dividing $50,000 worth of money over 4 people who were hurt in the wreck. So if you go to a trauma center like Grand Strand,
Okay.
$25,000 goes quickly.
Right.
And
What happens then?
well, if you don't have underinsured motorist coverage and the person who hit you has no assets, that's it.
Oh, okay.
So that's probably the toughest conversation we have with clients when somebody comes in. You can have terrible conduct, drunk driver,
Right.
terrible damages, $2 million of damages.
Oh no.
That person has $25,000, the minimum limits in South Carolina, and they have no assets. They got drunk on their own, didn't go to a bar to get drunk. And you have no underinsured motorist coverage.
That's it.
Your case is worth $25,000.
Oh no, how heartbreaking.
And that's and what 100% of those people tell me is, well, that's not fair. And it's not fair.
Right.
But it's the blood in a turnip again. And
Right.
so how to protect yourself in that situation is to get underinsured motorist coverage. Up your policy, get underinsured motorist coverage. And in South Carolina, that underinsured motorist coverage is actually stackable for all the cars that your family members are driving inside your household.
Okay.
But they're not driving inside your household.
Right.
People in your household driving on the road. So if I'm a family of 4, we got 4 cars.
That goes for all four
I've
cars.
I've got 250,000, 500,000 in UIM coverage on each car, and somebody hits me. Now I can stack those, so I can recover up to $1 million individually by stacking those four policies.
Okay.
If we were riding in one of those cars at the time of the wreck, and I got a cumulative amount of $2 million. So that $1 million single, $2 million cumulative goes on top of that minimum limits on the at-fault driver.
Okay.
That's getting deep. That's almost like a class at law school about insurance coverage. But
right.
let this be the takeaway. Get underinsured motorist coverage.
Okay.
And get a lot of it. It's a sad situation when somebody has bad damages and there's not enough coverage.
Right, because there's just nothing you can really do at that point. That's it.
That's correct.
So I know you talked a little bit about the underinsured coverage. What happens if the other person involved in the accident doesn't have any insurance at all?
You file under your uninsured coverage.
Okay.
So you would file a claim on your uninsured coverage for the negligence or recklessness on behalf of the at-fault driver. That is also stackable if you're driving one of your own vehicles. So if you have 4 vehicles in your household, you can stack those coverages to pay damages up to that amount.
Okay.
So the same example, the drunk driver got drunk on his own, wasn't at a bar, has no insurance, and you have $1 million worth of medical expenses.
Yeah.
And you got $250,000 of uninsured motorists, and you were in your vehicle at the time of the wreck, you can stack those 4 policies in your household and have $1 million worth of coverage.
So let's take that same example then, and let's say maybe there was a dram shop involved. There was some dram shop liability there. Does that mean you can maybe sue the bar that was over-serving the drunk driver, or how would that work?
Yeah, the dram shop liability is when in South Carolina, a bar or restaurant overserved somebody when they knew that person was intoxicated or should have known that person was intoxicated. They now have liability. What happens is that's on top of the liability coverage of the at-fault drunk driver.
Okay.
And that's on top of the uninsured or underinsured coverage that the injured person has.
Okay.
Okay. So that's real important to get full recovery for a lot of people who are injured by drunk drivers in South Carolina. We got terrible numbers in South Carolina. We got a lot of bars along the coast of South Carolina. And there's a lot of people here on vacation making bad decisions. So when that person goes to a bar, they overserve him, they knew or should have known he was intoxicated, he leaves the bar and hits someone. Now both the bar and the drunk driver have liability towards the injured party. And in that case, those cases we really need to investigate quickly.
Right.
Anytime we get a case that involves a drunk driver, we're going to find out as quickly as possible where they got drunk at. Where, did they go to a bar, were they at a house, whatever.
Right.
If they're at a bar, we are going to serve a letter of preservation to the bar telling them, do not destroy your credit card receipts. Don't destroy you need to preserve the surveillance cameras in your bar. Preserve anything that has to do with the person who was injured because of this drunk driver.
Okay.
And we don't try to get that information. A lot of times they won't give it to us, and we end up having to file suit to go get it. But that evidence and the witnesses in that bar can disappear very fast.
Right.
So we want to get that as soon as possible. And sometimes, if our client doesn't have underinsured motorist coverage, and the drunk driver has limited coverage or no coverage, if we can't get the information on the bar that overserved them, then our client doesn't recover.
Wow. But if you can, that might kind of open up a whole other pathway for you guys to go down.
In South Carolina, at this particular time, bars and restaurants have to have $1 million worth of coverage for overserving people. Okay. Now they're fighting that now. They're trying to fight and dodge some of that responsibility. up in the State House, but right now they have to have coverage. They didn't have to have coverage, I think, until 2017 it changed. So before 2017, if the bar served them, if they had no coverage, had no assets, you couldn't really recover anything from them either.
Now, okay.
But right now they do have to have coverage in South Carolina.
So that might change in the future then?
Hope not.
Yeah.
But there's a movement by the insurance industry and by some bars and restaurants
Right.
to try to take that responsibility off of them. They say they can't afford the coverage now because of so many claims, which
Right.
my response would be clean up your act and quit serving drunk people.
Right. So we'll kind of have to see what happens with that. I know we talked about that in our other podcast, but so I know that we talked about the importance of having underinsured motorist coverage. Is there anything else that you can think of that can kind of, I don't want to say ruin a case for a potential client, but is there anything else that plaintiffs should know before calling you guys that could kind of sway their case in one way or another?
That's broad. That's a broad question. If I was giving advice to people before they retain an attorney,
Right.
is be honest, keep everything private, do what you need to do for your own health and the health of your family, and get things investigated as quickly as possible.
So kind of going back to our example of the 3 legs of liability, collectability, and damages, what can you kind of do to ensure a strong liability leg or a damages leg or a collectability leg? How does that kind of work?
Okay. We investigate and then build those 3 legs.
Right.
Let's go liability leg. The liability, who caused the incident? Did someone breach a duty? Was somebody reckless? And
Okay.
there's bunches of, there's a lot of facts that go into that. But we're, in a typical car wreck, we don't get a private investigator on it to talk to the defendant,
Okay.
to take photos of the vehicles, take photos of the scene, see if there's gouge marks, see if there's skid marks, see if there's any surveillance at the scene of the wreck or going back down the road, which may show something. Pull the data from a car if we think somebody was speeding, to show what the speed was. Look at the scene, talk to the witnesses, talk to anyone who knows anything about it. We'll make a decision after we find out the coverages, whether or not we're going to do an accident reconstruction. Do we want to bring an accident reconstructionist in to prove and show the jury what happened? So that's how we kind of build the liability.
Right.
We also want to know, a lot of times you want to know things that you can't get on your own. For instance, if someone gets rear-ended by somebody going 45 miles an hour, they never touched the brakes, they were distracted, or drunk.
Clearly, yeah.
So if the officer didn't see any signs of intoxication, we want to know what they were distracted by, and most of the time it's the telephone. So we will ask the at-fault driver and the insurance company, hey, we need the phone records.
So would you kind of say that the liability leg is the thing that has to get investigated right away?
Well, we got enough people working on the case that we're doing all 3 legs at the same time.
Right away.
We have a team approach where we have an investigative paralegal, an attorney who are immediately working on the liability leg. We have a paralegal who's immediately working on the collectability leg, on finding out all the coverages.
Right.
And then we have 3 paralegals who are working on the medical aspect and the damage leg. So we can do them all at the same time. But from the liability standpoint, you just have to do whatever you have to do to show exactly what happened.
Okay.
Because another type of case we do is Dram shop, when a bar has overserved someone.
Right.
Well, the investigation on them is to get their surveillance, get their credit card records, get the names of everybody who was working for them, see if their waitresses and their bartenders were trained on how not to serve somebody who's drunk. We'll get a toxicologist expert in after we get blood alcohol levels.
Okay.
And that expert can testify as to the at-fault person's appearance back when they were serving them drinks. You have to back up in time to see if the wreck happens an hour after they left the bar and they blow a 2.0 and hadn't had anything to drink after they left the bar, a toxicologist will come in and say, well, if he had a 2.0 there, he goes what he had at the time they served him his last drink. You can show what his blood alcohol level. And that toxicologist can also say someone with a 2.9 would have been showing these symptoms. Anybody should have known he was intoxicated.
So in order to get that toxicologist in to look at the blood alcohol level, does that kind of mean you have to send in that preservation order first to the dram shop?
We send in a preservation letter to preserve anything to do with the bar.
Okay.
A lot of times when you get to a point where, at fault drunk drivers don't often say, yeah, here goes my medical records, here goes what my blood alcohol was. So sometimes you have to file a lawsuit to have the ability to subpoena and get those documents to prove your case. But that's part of the investigations.
So now kind of turning to damages, what do you have to do to investigate that leg?
Damages is a unique leg in that the injured party plays a huge role in the development of that leg.
Okay.
The liability, whatever happened to cause the injury has already happened.
Right. It's done.
The collectability, whoever had coverage, whoever had assets at the time of the incident, that's done. You really can't affect. The damage leg, moving forward from the incident, going forward, the injured party does have a say-so in those things. So if they're doing everything their doctor tells them to do, and they're trying their best to get better and to get back to their lives, they are strengthening their damage leg.
Okay.
If they're not doing what the doctor tells them to do, they are weakening their damaged leg. But investigating that leg, we always look at priors. We go backwards to see what we can show the health of that person was on the day of the incident.
Right.
And then we go in forward. And the damaged leg requires experts more than other legs. You got your treating physicians. Your treating physicians aren't going to give you a diagnosis. They don't give you a prognosis. They don't tell you what kind of treatment they need. At some point in time, that person's going to reach what we call maximum medical improvement.
Okay.
That's when the doctors say, we have done everything we can do. This person is as good as he will be.
Okay.
And here goes what his permanent restrictions are going to be moving forward, or his permanent condition is going to be. And here goes what his permanent impairment rating is. And he goes whether or not he can work moving forward, or what additional medical treatment he's going to need going forward. All of that takes expert testimony. So part of building that leg is getting the doctors to give you opinions. And a lot of times we get it from treating physicians. Sometimes treating physicians are busy. They're treating people. That's their profession. And we'll need to get another expert who will not only look at what that treating physician is doing, but also look at all these past medical records and give opinions based upon all of the health of the plaintiff. Give us opinion on causation, what was caused by the incident, and what was caused by an underlying condition, or was this condition that he's treating for caused by the wreck, or was it aggravated from something he had before?
Pre-existing.
So that takes a lot of expert testimony and medical testimony to show what the damages are. And then you may have you'll need a life care plan if they're going to need future medicals. You'll need an economist to convert it back to present day value. There's a lot of things, because when you go to court or when you settle the case, it's over.
Right.
I mean, you don't come back 10 years from now and say, hey,
what about?
This thing's gotten worse. Well, you can't do that. You got a 3-year statute of limitations in South Carolina. But once you settle, the case is tried, it's over. So what we try to do is find out as much as we can from the doctors to tell us that, based upon reasonable degree of medical certainty, what is the most likely outcome for our client. Okay. And that's the standard.
Got it.
It is more likely than not, based upon a reasonable degree of medical certainty, that this person will need medical treatment or this procedure in the future. And then we have to determine what the value of that is.
So how does it change your case if the doctor looks at you and says, hey, your client or the plaintiff has a pre-existing condition? How does that change your case?
Well, if you're over 30 years old, you got pre-existing condition. It's called wear and tear. So that's very, very common.
Okay.
And it's very common for the insurance industry to use that as a reason not to pay claims.
Yeah, I was going to say.
Once we start walking, we start wearing out. So most people have pre-existing conditions.
Right.
The question is, and pre-existing conditions actually can help you on some cases and can hurt you on some cases. On cases that they help plaintiffs, South Carolina has a law, and the purpose of the law is to protect people from birth to death.
Okay.
We call it the Eggshell law. Basically, it says if someone is negligent or reckless and they hit somebody and hurt them, they cannot then say, well, if they had been healthy, they wouldn't have got hurt.
Right, okay.
They take the person as they find them. So if you hit someone who's brittle, like an eggshell, and you bust them up, you're responsible for
You still busted them up, right?
So in that case, all these cases we build, I think the stronger your case falls into common sense.
Okay.
If you watch these focus groups, if you watch these juries, everybody's got common sense.
Right.
So if they see a fender that's not hurt very bad and you rode by that on the road, you'd say, well, nobody got hurt. That's just a fender bender. But if you saw this person's spine and how weak it was before this impact, and that she was having no symptoms to this body part, and then immediately after she had symptoms and needed surgery, common sense says, well, this wreck caused it.
Right. Or it aggravated a pre-existing condition.
Correct.
Okay.
And under South Carolina law, they're entitled to recover for that injury.
Right.
So it makes a case fall into the path of common sense.
Okay.
Now, the other way it hurts people, if you have a pre-existing condition, is let's say you have a pre-existing neck problem and it's bothering you. You're getting shots, you're getting treatment, you're getting physical therapy, and while you're getting physical therapy, you're getting a wreck, and it aggravates your neck. So now we're trying to determine
Aggravation, I guess.
aggravation of this pre-existing condition and whether or not it is a temporary aggravation or a permanent aggravation. So we're looking to see whether or not there's been any changes in the imaging before and after.
But if there's nothing in the imaging, then that's it, I'm assuming?
Well, it's not it, but it weakens the case. If there's changes in the imaging that you can show a jury, that's okay.
Okay.
Because of the eggshell plaintiff law. If there's no changes and the person just saying it's bothering me more, then it comes down to credibility. But it weakens the case if you're getting treatment and then you aggravate it. And then you have to determine when they're back to baseline.
Okay.
It's common sense that if you have a condition and get hit, it would aggravate it. But if there's no changes in the imaging, it's common sense that unless something has changed structurally, at some point in time, this person should get back to baseline.
So we've talked a little bit about how doctors can kind of help build your case and help assess damages in a certain way. What can a client do to kind of help their case?
I would say be honest, do what the doctors tell them to do, and just do everything they can do to help themselves recover.
So although the term collectability might be common knowledge for anyone that works in a law firm, what does that mean to the average person, or how might that be defined?
It is the ability to get compensation for our clients.
Okay.
That's got to come from one of two sources mainly. It's going to come from insurance coverage primarily, and it's going to come from assets if the damages exceed insurance.
Gotcha.
The problem is from an asset standpoint, when cases happen because of an individual's negligence or recklessness, very rarely do they have assets that can be collected in South Carolina to pay for damages.
So what would be an example of an asset that you could collect from?
Well, it's kind of a two-step process.
Okay.
Number one, does the client really want to go after somebody's assets for just simple negligence? There's a lot of people, and it's kind of where I fall on it. If somebody just makes a mistake, do you want to go after their assets and take assets away from them? If somebody's drunk,
Maybe.
it changes my perspective a lot.
Okay.
If somebody goes out and acts recklessly.
Right.
But that's up to our clients. We have cases where people have had assets. They've had rental property, so they've had real estate investments that they have to help pay for the damages. You hope those people have insurance, and most people with assets have insurance.
Gotcha.
But if they don't have enough legally, you can get a judgment against them and go after assets. South Carolina has a statute that protects assets to a certain extent.
Okay.
It protects so much equity in the house. If you're married, it doubles that equity.
Okay.
So there's a lot of things you can't get.
Gotcha.
It really comes down to somebody who has a bunch of free real estate, unencumbered by mortgages.
So paid off is what you're saying?
Right.
Okay.
And there's been cases like that where those individuals have gone and gotten a mortgage on the property and contributed to the payment of damages and then just paid it back.
Oh, okay. Gotcha.
So I think I've been doing it 35 years, and we've probably had 5 or 8 cases where people contribute assets. It's just unusual.
So why is it unusual? Do people just not want to do it? Or I know you said that sometimes there's not a lot of assets you can pull from.
Most of the time, there's no assets. I mean, we run an asset check to do our due diligence and show our clients so they can make a decision.
Okay.
Most of the time, they don't have assets. And most of the time, our client's not interested in other people's assets. They want to go after insurance, especially if they have enough liability insurance and underinsured motorist coverage on the back end of it to cover all the damages.
Gotcha.
If there's not enough liability and they don't have underinsured, then they have to make a decision. And if we represent them, we'll do what they want us to do, but
Right.
it's up to the client.
So you're just saying it's not typical that someone would want to go over those assets.
It is not typical that we will get assets to help pay for damages,
Gotcha.
mostly because people don't have them. By the time you go through the process of getting a judgment, doing supplemental proceedings, finding out what the property is, what the mortgages are, a lot of times it's just, when it's all said and done, there's not be enough assets to make a difference.
Gotcha. So I know we talked about assets in terms of our collectability leg. What else kind of goes into investigating collectability?
Well, as soon as we hired, I told you we have an investigative team who their job is to find out insurance coverage.
Right.
Every insurance coverage that could apply. If you think of insurance coverage kind of like a totem pole, the top coverage is the liability coverage on the vehicle in which the at-fault driver was driving.
Okay.
Second level is either an employer's coverage if that person was working at the time,
Okay.
or if that person was driving a non-owned vehicle, if he has liability insurance on his own car, that can come in as secondary liability insurance.
Oh, okay.
So if you're driving my car and you hit somebody while watching a TikTok video, which you better never do.
Never.
Okay. They're going to come after my coverage.
Okay.
And then they go after your coverage. And because you're working here, they could come after my coverage on the car, the firm's coverage, and then your coverage.
So in the case of secondary coverage in that example, would that mean that less would be taken from my coverage, or how would that work?
Yeah, I mean, the first, you have damages, my coverage is going to pay them up to the policy limits.
Mm-hmm.
If you were not working at the time and just driving my vehicle, then
For fun?
Yeah, for fun. Your coverage will kick in second. If it was work related, my business coverage will kick in secondly.
Oh, okay.
And then yours may or may not apply depending on the words of your contract, whether it excludes work.
Gotcha.
Out of the vehicle.
And so that would also depend on how bad the accident was and what the damages were,
Absolutely.
right? Okay.
Yeah, when we're investigating coverages, we're not even thinking about what the damages are going to end up.
Okay.
We usually have all the coverages identified within 45 days of being hired.
Okay.
So we look and say, we got this coverage, this coverage, this coverage. We have coverages in amount of blank dollars, and we have assets, we don't have assets.
Okay.
So within 2 months of us being hired, we kind of know, in most cases, what the coverages are.
Gotcha.
Now, if it's a trucking company, we won't know until we file suit and get all their policies, because they have layers and layers and layers sometimes in those trucking cases. If it's a premise liability case, they're not going to give us their coverages until we file suit. Under South Carolina law, the auto insurance carriers have to give us the coverages.
Okay.
And that was,
so they can't withhold that.
when I started practicing law, they didn't have to. We passed a law that says they got to give it to us. So we can ask them, what's your coverages, send them the necessary documentation, and they will send it back to us. So we know that within 45, 60 days of being hired.
Gotcha.
And then you look at that, and we know that trucking companies have mandatory insurance. We know most premise liabilities, businesses and hotels, they have insurance. So we know in car accidents, non-commercial at-fault drivers, we know their coverage is usually within 45 or 60 days.
Okay.
When you're talking about commercial policies or premise liability cases, we won't know those for sure, total, until a suit's been filed and you get those. They have to give them to you when you request them in litigation.
So I know you said you have about 45 to 50 days to really find out what the coverage is. Is that due to a certain amount of time the insurance company has to let you know? Or how does that work? How long does the insurance company have?
I think it's 30 days after we request it, they have to give it to us.
Gotcha.
So there's a time they have to give it to us. A lot of times they tell us verbally on the phone, and then we'll get a letter
Gotcha.
to confirm it.
Okay. So now that we have a pretty good base understanding of collectability, damages, and liability that all kind of play into our barstool example, how do they all support each other?
They're all very related.
Okay.
Like I said, we know collectability, insurance coverage, we know that quickly. We usually know that before the full extent of damages.
Right.
The liability, we want to know that within 60 days. We want to find out every fact that you can find out without litigation within 60 days.
Right.
So 2 months into our representation, we want to know the strength of those two legs.
Gotcha.
And then the damage leg, it continues to be built until the person has reached maximum medical improvement and we got all these opinions. But they play together. These focus groups we do, the degree of damages can have an impact on the liability question. And the act of the at-fault driver, whether it's just simple negligence or reckless,
Right.
actually has an impact on how much they pay for the damages,
Really? Okay.
even though they're separate legs.
Yeah.
So a bad actor, a drunk driver, can increase the value of actual damages as well as punitive damages
Gotcha.
because of the degree of recklessness. So they play together. Those two play together. The collectability is kind of sitting there and say, hey, whatever you get out of that, this is the max you're going to be able to recover.
Okay.
But the other two kind of play together.
So collectability is kind of all encompassing of the other two legs.
Yes.
Gotcha.
It doesn't set the value of your case, but it often sets the max value of your case.
And is that kind of what juries determine? Like how negligent a person is, how reckless they are?
Correct.
Okay.
The jury has no say-so in collectability.
Okay.
Unless there's a question regarding whether someone was working at the time,
Right.
or whether someone had permission to drive a car.
Oh, okay.
That can make a difference. If I did not give you permission to drive my car and you stole it out the parking lot, then my insurance company could deny coverage.
Oh, so then my secondary insurance would then maybe be primary.
That's correct.
Gotcha.
So you got to have permission to have my car, otherwise you're stealing it.
Okay.
So don't take the keys off my desk.
Okay. I'm looking around for them right now.
So there's facts like that that a jury can have a say-so, but usually they're determining, was this negligence? Mm-hmm. Was it reckless? And what part did the plaintiff play in it? Because the plaintiff, because of comparative negligence, can reduce the value of a claim. So that's part of the liability question.
Okay.
Trying to show that the plaintiff didn't do anything wrong. In South Carolina, we have a law called comparative negligence. Mm-hmm. And what that says is the jury gets to decide how much the at-fault driver, who we're calling the at-fault driver, contributed to this wreck happening.
Right.
Were they negligent and they contributed these damages? They also look at the plaintiff and say, did the plaintiff do anything negligent? How much did they contribute?
Okay.
They come up with what part they both played in it to come up with 100% responsibility of the claim.
Gotcha. And that's maybe where that honesty part comes into play in terms of the plaintiff and making sure that they're going to the doctor and doing everything as recommended.
That's right.
Gotcha.
They're looking at everything.
Right.
And they look at everything to see if the plaintiff did everything right.
Posted on social media, those types of things.
They're looking at everything. And they're looking at who caused the incident. On a slip and fall case. Well, was there a defect? Did the owner of the facility know about it, or should they have known about it? Did they cause it? And did the plaintiff protect himself or herself by being careful? And in a car wreck, same thing. How much of the fault is on the plaintiff? How much is on the defendant? In South Carolina, whatever verdict or whatever damages come out, it is reduced by the percentage of fault of the plaintiff.
So they could get less damages if they're found to be at fault at all.
Let's say there's $1 million worth of damages.
Yeah.
The jury finds the plaintiff 30% at fault, then the plaintiff's only going to collect $700,000. If the jury finds it's a 50-50 case, they both are 50% at fault, that $1 million verdict becomes $500,000. If a jury finds that the plaintiff was 51% at fault, and the defendant was only 49% at fault, the plaintiff gets nothing.
Nothing. Yeah. I think we talked about that in our last podcast too. Yeah.
If the plaintiff's negligence exceeds the defendant's negligence, the plaintiff in South Carolina gets nothing.
And are some of those things that could kind of push that over the edge to from the 50 to the 51%? Could that be posting on social media or, maybe not getting evidence right away? Are those the types of things that kind of take it from that?
No, those are the types of things that the other side is looking at to see if they can find facts to increase the negligence on the plaintiff's part.
Right.
So let's say somebody posted something on social media right afterwards, and in that post, they say something, I was listening to this TikTok and this person came and hit me.
Yeah.
But they've just admitted they were distracted. So their distraction plays into the formula.
Right. And then that's evidence.
That's evidence.
Yeah.
So they, like I said, from our standpoint, we're looking for every fact that exists in the world as to why this happened and what everyone was doing at the time.
Right.
And the insurance company's doing the same thing. They're trying to find any bits of evidence they can find through your social media, through witnesses, through anywhere that says that you were partially at blame. So they're doing the same thing on their side.
Right. So honesty and getting the facts is key.
Correct.
So let's say after looking at all these factors, there's someone that's still a little bit confused on what the validity of their claim is. Are there any next steps you'd recommend in order for them to figure that out?
If someone has a question about validity of a claim, they can contact us.
Okay.
We often can tell people on the phone if we know there's not a valid claim. If there's facts that the state has not recognized as being a civil cause of action, we can tell them that.
You can let them know.
Yeah. If there's no damages, that's bad act, but no damages, we can let them know. If it's a bad action that we know there's no way that's going to be covered by insurance and that person probably has no assets, we can let them know that too.
Right.
But we sign up a lot of cases when we don't know the strength of the legs. I mean, until you investigate it, you don't know.
Right.
And in those cases, we sign up cases, we tell people very often, we say, hey, there could be facts here that would give you a valid claim, and there may be facts that show that it's not a valid claim. But if you'll sign up with us, we will investigate it. We're going to find out everything we can find out about it, and then we're going to come back to you and give you the truth about what it shows.
Give them a valid answer.
And if we run into a roadblock and they have no valid claim, we'll tell them that, and we can close the file. We won't charge them any money. If we spend money on costs, we eat it. And but we will have investigated, and they will have known whether or not there's a valid claim.
So what you're saying is that if someone calls you up and asks about their case, you're going to take a look at the 3 legs of the bar stool and give them your accurate answer.
That's correct. And if it needs investigation, which a lot of them will need investigation, we'll investigate it.
Yeah, take a look at it.
We understand that there's going to be cases that we're going to sign up and we investigate that the facts aren't going to be there. But until you look, you don't know.
Right. Absolutely. Thank you so much for giving such valuable information about the truth, about the validity of your claim. I know I learned a ton. I'm sure viewers did as well. And we look forward to seeing you next week.
Looking forward to it. Thank you.
Thanks.
Thank you for joining us on the Legal Truth Podcast. If you have questions that you would like answered on a future episode, please send them to thelegaltruth@derricklawfirm.com. If you would like to speak to us directly, call us at 843-248-7486. If you find the podcast valuable, please leave us a 5-star review and share the legal truth with your neighbor, friend, or family member who is seeking reliable information about a South Carolina personal injury or workers' compensation claim. Dirk J. Derrick of the Derrick Law Firm Injury Lawyers is responsible for the production of this podcast, located at 901 North Main Street, Conway, South Carolina. Derrick Law Firm Injury Lawyers has included the information on this podcast as a service to the general public. Use of this podcast and any related materials does not in any manner constitute an attorney-client relationship between Derrick Law Firm Injury Lawyers and the user. While the information on this podcast is about legal issues, it is not intended as legal advice and should not be used as a substitute for competent legal advice from a licensed professional attorney in your particular state. Anyone seeking specific legal advice or assistance should retain an attorney. Any prior results mentioned do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants in the podcast and are not intended as endorsements of any views or products. This podcast could contain inaccuracies. The information contained in this podcast does not constitute legal advice and is not guaranteed to be correct, complete, or up to date as laws continue to change. In this podcast, you will hear information about focus groups. Please note that not all of the firm's cases are presented to a focus group. Additionally, when speaking about juries or jurors in relation to a focus group, we are speaking of focus group participants and not actual trial juries or jurors.